On Friday, you'll be asked to vote on two amendments, the Family Amendment and the Care Amendment. And we've been hearing from our listeners that there are still questions to be answered. So joining us once again to do just that is Miss Justice Marie Baker, Chairperson of An Comisiún Tábhain, Ireland's Independent Electoral Commission. I'm worried, as I'm single by choice, I could end up not being single inadvertently. Everyone can marry, can divorce, can live together formally. Now I cannot even have a boyfriend, or I could end up with someone claiming part of my home.
Oh dear! Right,
this I presume is the durable relationship.
It's a durable relationship question. Yeah, it is. No, it's an interesting question, and it's part of the discourse around this. You can't end up in a durable relationship by accident. You must mean it. Whatever else durable relationship means, it must mean something where people intend to be committed to one another.
Let's scenario this. So we've got two people who are house sharing, and they're pals. And they share this house. One of the parties owns that house and the other is staying there, perhaps paying rent, but as pals, perhaps not.
As pals, perhaps not.
And suddenly decides, hang on a second, I know we're not having sex, we're not sleeping together, but this is definitely a durable relationship.
It is, yeah, but it's not a family. They're friends. I think that actually is easy to answer.
That.
I don't think
How
so.
do we know you're not having sex?
I will know. You either say you are or you're not. Nobody knows from the outside. That's your private life.
Could that not be argued in the courts then?
It could, but remember, the expression durable relationship is intended to be put here on the basis that it's a durable relationship defining a family unit in society.
Suppose
so you must
one of the
present
parties,
as a
the
family
owner
unit.
of the flat, has a child. And
yes.
Both people are not, acting necessarily as parents, but certainly in that, from the outside, it might look that way.
Well, if they look like they're in an intimate relationship or we're in an intimate relationship, they might look like they're a family from the outside, but they must mean to be that. A durable relationship.
But I think this person is worried that the other person might mean to be that. And
I think there is actually an answer to this. First of all, you can't end up living with a boyfriend or a girlfriend in an intimate or some way intimate relationship as lovers, as it were, unless usually you end up some way financially interconnected. If you do, the present law provides, leaving aside divorce, separation, any of that, the present law provides that you may well find that your boyfriend or girlfriend comes to own part of the house if they pay part of the mortgage. This is ancient law.
Okay.
It's the old equitable principles from the 19th century. Contribution to the acquisition of property gives you a right in the property. You would say, if you were being sensible, that you would enter into a cohabitation agreement with somebody before you ended up doing that, but nobody does, Pat.
Yeah.
So this woman could not find herself with her boyfriend owning her house unless they either agree that he's contributing to the mortgage or implicitly he's contributing to the mortgage.
But this whole thing of, marriage versus a durable relationship, that question, I'm in a durable relationship, therefore the rights should accrue to me as if I were married, because we've now disposed of the marriage thing. We're now talking about durable relationships, and I've been in a durable relationship with this person. I want some of her house.
Yeah, well, two things. First of all, we have not dispensed. It's not proposed to dispense with marriage. Marriage will still have a degree of priority, so it will be legitimate for certain additional protection to be given to marriage. But second of all, the Cohabitation Act from 2010, 14 years old now, and the Civil Partnership Act provided for claims to be made by people who cohabit with one another. Not because they were married, but because they cohabited.
Next one. Can you ask if the Electoral Commission has any teeth or ability to sanction several government TDs who've repeatedly made erroneous statements that the Constitution states that a woman's place is in the home? We know it doesn't, yet they keep repeating this misinformation.
Right. Well, that's an interesting question about the role of the Commission. As you know, parts 4 and 5 of the Act have not been commenced. And the word disinformation and misinformation are actual technical words. I prefer to say factually incorrect. There's been a very active debate here. And there's no doubt that some people have relied on certain legal principles to further their side. There have been one or two occasions when An Comisiún has called out a factual inaccuracy. We very early on called out that fact that the Constitution doesn't say a woman's place is in the home. we called out something this week where there was a poster saying, if this referendum passes, women will have to go out to work. That's simply not legally correct. But we don't think facts and opinions should be mixed up here. So that's how we've
But you do
approached
try
it.
to call them out when
If there's a fact that's likely to be in some way taken up and run with, when it's so factually legally incorrect, we call it out.
Another one, why is the constitutional amendment, there are two of them, deliberately vague and open to interpretation?
I think you should ask the politicians that. We have these words. These are the words we're trying to explain in an impartial way by relying on facts.
I suppose we should say, in fairness, they did struggle to come up with wording, didn't they?
I think they did. From what we know, they struggled to come up with wording. But you know, even the word equality in the Constitution requires some clarity from time to time. Language around relationships can need clarification.
Questions are flooding in, so we'll get through them as quickly as we can. Will the changes regarding marriage, family and caring have big implications for social welfare?
That will depend on, I'm sure I said this on the last day, Pat, that the first thing that would happen if either of these proposals passes is that the legislation would have to be looked at to see if it meets the new constitutional definition of a carer or of a family. The big change in social welfare has probably already happened with the O'Mara case. The Supreme Court said that it was under-inclusive. It didn't include that particular family unit. There may well be other places where this will happen. I don't know where they are. And it's really not my job to give an opinion as to what has to change. I can just say what has to be looked at.
Now, if the government wins the yes vote and the constitution is changed, how could a court not take it into account that if a man had, for example, 4 wives under his country's laws, if he demanded political asylum in Ireland, or if an Irish father was married in one family but living with another in which he had children?
Well, oddly enough, that question has a straightforward enough answer. It is not possible to be married to 2 people under Irish law. The Irish Constitution recognises that a marriage is between 2 people.
So he would have to choose which one he brings
No,
into the jurisdiction.
I think it's worse than that. I think the first marriage would be the one that's recognised.
He doesn't get to choose.
No, we actually had a case on this in about 2019 in the Supreme Court. It was a Lebanese family, and the man was married to 2 different women, and one of them came with him, the younger one. And the older one then tried to argue that she was also married to him. And the court said, no, the constitutional ethos does not recognise that you can be married to 2 people. As a matter of domestic criminal law, you can't marry in Ireland to a second person. But the court went on to say something very interesting there, actually, because it said that a marriage is a relationship of equality between 2 people, which respects the individual equal rights and respect and dignity of the other, and that a marriage that allowed the man, it was nearly always the man, to marry someone else would not actually reflect that equality. So there's a long way to go to have us recognise those type of relationships, and they absolutely are not now, irrespective, I think, of what would happen
Here's another
to the
one.
Constitution.
Could you be married to someone while in a durable relationship with someone else, i.e. waiting for a divorce?
Well, that's, again, oddly enough, the cohabitation legislation that I mentioned a moment ago from 2010 actually provides that you can't be a qualifying cohabitant unless you are either not married or separated long enough to get a divorce. So the answer is, it's likely that under current law that the answer is no. The law would have to be looked at to see whether it needs to reflect a new thinking, but that's the current state of the law.
Another one, when a person is under coercive control but not married, is that a durable relationship?
Oh, well, again, oddly enough, if coercive control means that you're not, in fact,
free.
Objectively speaking, free. So I can't, if a relationship is between 2 people of 2 equals who commit to one another by virtue of an informed choice, then a person under coercive control is neither married nor in a durable relationship, I think.
What about stepchildren? My stepchildren are provided for in my husband's will, but not in mine. He took out a separate life policy for them. But could they say they had a durable relationship with me and then contest my will, because that would put my biological children at a disadvantage?
As it stands, the answer is no. The succession, in fact, is very much controlled by law. You can't exclude your spouse, but you can exclude your children. And the only stepchildren, and that's not really a word, a legal word, but the only children who are not your biological children who can make a claim against you are children to whom you are in loco parentis. And then a child may only make a claim if they can say that proper provision wasn't made in your lifetime. So bit remote, I would have thought.
Yeah, there's a huge number of comments or questions coming in about the same
I'd
thing.
say, yeah.
Can you have two durable relationships at the same time?
Again, I think the answer has to probably be found in that case I mentioned from the Supreme Court, given that a relationship is one of equality between people. It would seem on current thinking that the answer is no. But maybe there are people who have multiple sexual partners, but that is probably, from their point of view, their private life rather than their family life. And remember what I said a moment ago. What's proposed is to put into the Constitution a recognition of a family unit based on a durable relationship. I don't know how many family units are based on relationships where there are multiple sexual partners in the relationship. They might be privately having several relationships.
Is about caring. I would like to inquire about the family carer. If a member of my family was available to care, but I was not happy with them doing so, what are my options now? Can I still apply to the HSE for care, or will I have to accept this available carer from within the family?
No, I think the current state of the law, the current provision in the Constitution recognises the care provided by women in the home. It doesn't say you must use that care. It recognises that it has a value. The proposal is to recognise the value of family care, not to force you to have that.
Can I now get equal tax treatment as a married couple if I'm in a genuine, durable, but not cohabiting relationship? Otherwise, I would be discriminated against and denied my new constitutional rights. That's a question.
That's a good question, actually. The current position is that married people have favourable tax treatment as a result of a decision called Murphy in 1982. I hope it's 82 and not 84. That case was resolved on the basis that it was legitimate and indeed proper and required that the state would give special protection to the institution of marriage. The institution of marriage is in 41.3, and it's not proposed that would lose its special status. It would have to be looked at. But that would be a starting point, that case.
A number of people coming in with this question, whether or not the whole thing has been too rushed, and therefore they question its legality to have a referendum at haste just to coincide with International Women's Day.
I have no comment to make about International Women's Day, except that these proposals went through the Oireachtas, they went through the Dáil, the Seanad, signed by the President, and the date was fixed. So whether it's rushed or not, we've run the campaign we wanted to run. You
take what you're handed.
We take what we're handed.
Yeah.
We've run. I think I've done about 55 things by now.
This one, I'm in a relationship for 8 years. We have a child together, but we don't live together. Are we considered in a durable relationship? Are we considered as spouses, and would inheritance laws apply?
They're not spouses. So current inheritance laws do not apply. They're not cohabitants. So the 2010 Act doesn't apply. Those people should first of all know.
I mean, what they're doing is jointly caring for their child.
Yeah, but they're free to make provision in their wills for one another. That's what perhaps people should think about. There's nothing in the current proposal that suggests that durable relationships have to be cohabiting relationships, but that's the paradigm we have at the moment. So I don't know the answer to that, and I actually think I'm not inclined to give an opinion on it.
This one, and probably this will be the last one. Listening now to the definition of a durable relationship, it seems that this does not include the single parent. So are they represented in any way in the family amendment?
This in fact hasn't got much traction. How I answer this again? The minister, the Taoiseach, everybody has said that it's intended to cover a single parent family. The O'Mara family was regarded by the Supreme Court as a family unit, even though it was headed by one person, one
because
parent,
he was
the father.
widowed.
Yes. And the Supreme Court gave examples of families headed up by grandparents, families headed up by the older sibling when the parents are both dead, families headed up by a single parent. They said they were family units, but not constitutional family units. So it's possible that if this came to be considered either by the Oireachtas or ultimately by the courts, that particular analysis would form the basis for it. the relationship between mother and child is the most durable relationship that we know. Ask any mother who's told she can't leave the house.
There are questions
without her children.
which I'm not giving to you about ballot papers and the wrong address and all. They're for your local county council, aren't they?
Yeah, well, look, people can vote if they're on the register. They don't need their polling card. It's handy to have it because it's an easy way to show it to you.
But you bring an ID.
Bring your ID. Check the register. Check to see if you are registered. It'll show you registered and go along and say, "This is me. Here's my bank card or my
Driving license.
Driving license. I mean, we all have some ID now, really.
And a utility bill will confirm
Yes,
your
anything.
address,
I mean, the polling card is just handy.
Yeah. All right. Judge Marie Baker, thank you very much for
you very
joining
much.
us and clarifying as much as we can the forthcoming referendums on Friday. Marie is chairperson of An Comisiún Tábhachtán, Ireland's independent electoral commission.